Hello, everyone. Welcome to the Ray Law International channel. If you are interested in getting a green card, or if your employer is not cooperating, or maybe you're abroad and you're looking for a way to come to the United States and you meet some of these standards, you need to pay attention today. We're going to talk about how to get your green card without anybody knowing, let alone the rest of the world knowing. Hello again. My name is Anthony Ray. I'm one of the attorneys here at Ray Law International. It's so glad to have you here today. Today we're going to be talking about the National Interest Waiver, and it's going to be really important. So stick around. We have a lot of information to pass to you. Now, for our format today, what we're looking at doing is we have some prepared questions and a flow for our program today. However, feel free to jump in the chat section or comment section with your questions. Let us know what's on your mind from immigration. If you have questions, midway through, we have a special question to let you guys get to know us a little bit better. So stick around for that. I think you'll like that one. And feel free to give your answer to that question also. And finally, if you have other immigration questions that are not on topic, maybe it's a family-based green card question or an asylum green card question, feel free to put that in the chat. One last thing before we continue our introductions is feel free to put your chat or your comment or question in English, Spanish, or Japanese. I mean, if there's some other language out there, we'll use Google Translate, but we have people standing and waiting for your questions. So feel free to put those comments and questions in there. We really like those. That makes our webinar even more interesting and exciting and useful for the whole community. Lauren?
Hello, good morning, everyone. My name is Lauren. I'm one of the attorneys here at Ray Law. I focus on employment-based immigration as well as family-based. We do a mix of both. So like Anthony said, any sort of questions you can have, we'd be happy to answer them. And yeah, that would be about it. Saki?
Good morning from Chicago. My name is Saki Sadaike. I'm a legal assistant at the Chicago office. Chicago is kind of cold weather today. And also I'm Japanese assistant. And おはようございます。シカゴオフィスの貞池と申します。今回のライブストリームに関しまして、質問がある場合はコメント欄へご質問を投稿してください。または、弊事務所までお電話、もしくは E メールにてお問い合わせください。ご質問にお答えいたします。よろしくお願いします。
Hi everyone, my name is Anai and I'm the client sales manager here at Ray Law, and I am not fluent in Japanese like Saki, but I am in Spanish, so if you all have questions in Spanish, go ahead and feel free and leave them in the chat. So are you ready? Let's go ahead and get started. So for Lauren, what does NIW stand for? Why is it called that?
So NIW stands for National Interest Waiver. It is called that because normally when you have an employment-based petition, you would need some sort of certification from the Department of Labor stating that the company hiring you is not going to displace a U.S. worker, a U.S. citizen, or a green card holder. However, there are certain positions for which it is in the national interest to waive that requirement to get that certification from the DOL. So we'll get more into what types of positions qualify for the national interest waiver. However, just in general, it's only to waive that requirement for that labor certification, which can be very helpful.
Thank you, Lauren. The question to Anthony. Under the EB-2 category, is the national interest waiver the only option?
Thank you, Saki. Actually, excuse me. Actually, it is not. overall, there are 5 employment-based preference categories. And we're just looking at the EB-2 category. Under the EB-2, there are 2 subcategories. Today, we really just want to focus on just one of those, and that's going to be the National Interest Waiver. The other one, which we can discuss in future webinars, or feel free to check out our YouTube channel, is information on that process, which is completely different than what we're dealing with here with the National Interest Waiver. So the answer to that is no, there are actually 2 options under the EB-2 category.
Thank you, Anthony. For Lauren, what were the 3 requirements under the NYS DOT?
Yeah, so NYS DOT was a court case. So yes, it has to do with New York State Department of Transportation. That's the reason for the acronym. But in general, in that case, the court said that a person who is applying for national interest waiver must seek employment in an area of substantial intrinsic merit, that the benefit to the country would be national in scope, and that the national interest would not be adversely affected, or the national interest would be, adversely affected if a labor certification would be required. So again, this was a court case, and those were the qualifications needed for a national interest waiver. Hi, JJ.
Okay, thank you. Question to Anthony. What are the current requirements under the matter of Dinosaur?
All right, thank you, Saki. I'm going to put some of those requirements up on the screen here for everyone to look at, as we just looked at the NYS DOT. For Dinosaur, our foreign national there's 3 requirements also. One, that the foreign national's proposed endeavor has both substantial merit and national importance. We'll talk about that a little bit more. Second is that the foreign national is well positioned to advance the proposed endeavor. And third, that on balance, it would be beneficial to the U.S. to waive the requirements of a job offer, which is essentially the labor certification process. Now, one of the things I want to highlight in this standard, both previously and under this new standard for Dinosaur, is this is a matter of discretion. Okay, one does not have a right to this. It's really up to the USCIS to grant that discretion once you meet all of these requirements. So you want to keep that in mind, that some of these cases can be challenging, and we'll talk about a few today where obviously we think they should be approved, but the USCIS, based off of their review and ultimately their discretion, decide not to grant this waiver. All right.
Lauren, what are a couple examples of approved cases post-Dinosaur?
Yeah, so there are a bunch of different types of cases that can be approved. It's not going to be necessarily just kind of what you would typically think, we need engineers and doctors, right? So some of them are entrepreneurs, manager for commodities trade and supply company, that was stating that the person was helping small businesses stay in business. People in the field of music, someone who played an accordion, and international relations, so specialist in North Korea. There are a ton. So basically what we want to get across here is that just because you may think that your field doesn't necessarily have an obvious and national interest, it actually may, depending on who you are and kind of the arguments that we can come up with.
Okay, thank you, Lauren. Anthony, what are a couple examples of denied cases post-Danaher?
All right, thank you, Saki. There's a lot of denied cases. Actually, we're just going to look at two real briefly today. And let's see if I can, just going to share my screen so we can take a look at the first one. Just a second, bear with me. Here we go. Let's see, here we go. Great. So on the screen, you'll see the first case we're going to look at real briefly is a person who was a minister under the community development outreach. Often some people may think, well, I'm just a pastor or ministry outreach. It really doesn't qualify. But in this case back in 2017 or before then, this was actually the decision. So the case was obviously filed way before then. But here, this minister, because of the work they were doing, reaching the community, the attorney or the respondent argued that it was in the national interest to forego that labor certification process. Unfortunately, and this was on a Denisar's review, the court felt the USCIS made a decision and found that there was a lack of specificity as to, how it would benefit the U.S. Now, a lot of these terminologies are very, very technical, and that's why the attorneys are involved and we argue and, look at the definition of all these words. But in this, the person was impacting the community. Unfortunately, the court found there was not enough specificity as to who would be benefited. So that's one of the aspects. The second one we're going to look at is, and you'll see here they have the matter of R-FM. That's really just to protect the, the person's name and everything. So that's not made to the public. So on this one, which I thought was very interesting, it was an NIW case for a teacher at a secondary mathematics in the STEM field. As you know, in the US, STEM occupations are very important, and it's part of our national interest to, keep our country at the forefront of technology and moving forward. Therefore, the argument we hear was, the work he's doing impacts, the U.S. And the national interest, but unfortunately, this also failed because they felt that it was not national in nature. Yes, it's something the nation was interested in, but it didn't really impact the nation as a whole, just really limited to their area or jurisdiction. So these are a couple cases that I just wanted to pull out and highlight, and I thought were of interest that we can talk. But there is a lot more out there that we could talk and go over.
Thank you, Anthony. So, Lauren, what forms are used in filing NIW petitions with USCIS? Where is the petition field?
So the forms used would be the form I-140. That's an immigrant petition for alien worker. That would be, you would fill out yourself as an individual or obviously with the help of an attorney and sign off on it. It gives information about the petition, about your position, excuse me, and your salary, things like that. You would also file most people can file jointly the form I-485. That is the form for adjustment of status, which is basically a green card form. So you could file those two jointly. Unfortunately, there is no premium processing, so no I-907 for those petitions that are national interest waivers. Where is the petition filed? That is going to depend on where you live. So either go to the USCIS website and look at where to file the form I-140, or definitely speak with an attorney. It's also going to depend if you're filing jointly the I-485 or not. So that is going to vary. Anthony?
Thank you, Lauren. Anthony, what are the filing fees related to NIW case?
Okay, just one moment. Let me pull that up. Thank you, Saki. So the filing fees related to this petition is the I-140. The petition is for an alien worker, Form I-140. The filing fee for the I-140 is $700. Okay. Now, as Lauren just mentioned, unfortunately for this category, we cannot use premium processing. So the base fee that you're going to pay for this petition is going to be $700. Now, if you qualify, or if you're from a country where the visa numbers are current, then you can file your application for adjustment of status. But since we're going to limit our discussion today to just the EB-2 National Interest Waiver and the Form I-140, we're not going to discuss the fees or filing fees related to the application for adjustment of status or an immigrant visa application. Oh, one last thing. We did have a comment about H-2Bs from a prior conversation. The comment is correct. Right now, for Indian nationals, H-2Bs are not available. But what I would like to say, each year, the government does update that depending on the number of people coming from that country. So always look to that. If H-2B is not available, feel free to look at other visa categories, such as the J-1, maybe an H-3, or feel free to send us your resume detail for us to analyze that to see if you may fit in other visa categories. There's a lot out there, so feel free to send that resume in and have us analyze and take a look at that. Thank you for the question.
Thank you. Lauren, how long will it take for me to get a green card under the NIW?
So this will depend, like Anthony said, if the category is current. For Indian nationals, EB-2 has a very long wait. So you may be waiting, even though your case is approved, you may have to wait 10 years for the visa bulletin to be current for you. If you're from another country, such as, for example, Mexico, I know that EB-2 is current right now. And for those people filing jointly for the green card, if they're located in the US, you're looking at probably 1 to 2 years until you have the green card in hand. Now, that does come with a work permit in the meantime. That's a whole nother discussion. But processing times are pretty bad right now, and they just seem to be getting worse. So I would budget at minimum a year, could be up to 2 years. Usually your I-140 will be approved first, but I do have some people right now, the I-140 is approved and they're still waiting. It's been about 6 months after that for that actual green card. So keep that in mind. You'll likely have some additional time there. If you are outside of the country, you would not file the Form I-485, you'd just file that Form I-140. Depending on where you file, your I-140 will likely take probably 6 months to a year. It really depends. Anthony's saying no, it'll probably be longer, 8.5 to 11. It depends on the official who is handling your case, right? If someone's going faster, it may be faster. If that official has a lot of cases or they're moving a bit slower, you're going to be at the longer end of that timeline. Once your case is approved, if you're outside the US, like Anthony said, you would apply for that immigrant visa directly with the consulate in your country. That process also is taking long. Everything in immigration takes forever these days. So definitely budget, I would say, at least 6 months more for USCIS to send your case file to the consulate, to get all those documents submitted, to actually schedule your medical exams, schedule your biometrics, and finally attend that interview and get the visa. So definitely not too quick of a process since we can't use the premium processing, but it is a very good path for a lot of people.
Okay, thank you, Lauren. So Anthony, can I file more than one immigrant petition I-140 with the USCIS at the same time? For example, an I-140 based on the National Interest Waiver, and then an I-140 based on the case under the EB-3 category.
Well, Saki, the quick answer to that is yes, you can. Now, so you can file an I-140 under multiple categories. At the beginning of our discussion, we talked about there being 5 employment-based categories. Not all of them require Form I-140. However, a lot of them do. So for example, you could file, as the example has, an I-140 and get it approved under the EB-3 category. Under the EB-3, it may be a professional, skilled, or unskilled. Likewise, you can also file under the National Interest Waiver, EB-2, an I-140. So what I wanted to share is, again, on our screen, it'll come up, is as you can see, there are multiple categories here when you complete the form I-140. This is Form I-140, and it's 9 pages. And here you can see there's EB-1 categories such as extraordinary ability, outstanding professor or researcher, multinational executive or manager, and others. But we're going to be looking at that National Interest Waiver category here. Let me pull that down. 1H, who is a member of a profession holding an advanced degree or an alien of exceptional ability. That's the category we're going to be checking and filing under. Now, I've heard some attorneys, don't quote me on this, some attorneys would check more than one box on the same form. Other attorneys would file 2 separate applications. For example, one is a professional under the EB-3, for example. Let's say you're an engineer, and then a separate one under EB-2. We're not going to get into practice styles or management, but typically what we do is we will file 2 separate applications to make sure that one is not rejected if something is not approved by the USCIS.
Thanks, Anthony. For Lauren, can I maintain my H-1B status while filing just the I-140 petition for the NIW? What are the pros and what are the cons?
Yes, so pues de primero, hola Mori, gracias por su comentario, me gustan sus emojis. Estamos muy bien, gracias por su comentario. So I was just saying hi to Mori, to anyone who doesn't speak Spanish. But yes, if you're on H-1B status, I would definitely recommend to maintain that while you're filing for the NIW. First of all, if you are from a country such as India where EB-2 is not current, you need some other status because I-140 does not give you a status. Until you get that green card, I-140 is not giving you any sort of status. Let's say you're from another country, example, Mexico, which does allow currently individuals to file for the green card at the same time as the I-140, I would still recommend maintaining H-1B status. And the reason being is because of the horrible processing times right now. The H-1B status and the work permit that comes with the I-45 allow you to kind of have a backup. So if your work permit is going to expire and the processing times are really bad, you still have that H-1B to rely on, and vice versa. If something happens with your H-1B status, you can then rely on that work permits. So it's not necessary to maintain that H-1B status. However, I do recommend it at this time just because of the processing times.
Thank you, Lauren. Anthony, so can I maintain, I'm sorry, do I have to have an employer sign the NIW petition? Do I have to have an offer of employment?
So for the first question, thank you, Saki. Do you have to have an employer sign the NIW petition or the I-140 petition? And the wonderful answer to that, and this is the whole point of this webinar, is no, you don't. So you don't have to find that U.S. employer, which most of the employment-based categories do require. It's great. This is a way for no one else to know that, hey, I'm a physician, I'm an engineer, I practice in this specialized field or this area, and it's going to benefit the U.S. File for that, get approved, get your immigrant visa or get your green card, and you're all set. You do not have to have an offer of employment, okay? Which is perfect. Now, remember when we talked about the rules under DONASAR, you have to have the skills and everything required in order to succeed in whatever that endeavor or goal is that you're saying that you're a professional in. And that's so inherent in the NIW process is, no, you don't have to have a job offer, but you're definitely going to be working and benefiting the U.S. and the way to do that is through work. So inherently, you're going to do that. One of the benefits of DONASAR that the court talks about in the case is this could help out a lot of entrepreneurs or people who don't have a big company or they're starting off. So this is going to open that door. It's going to make it a lot more, what do you want to say, probable that these individuals who under the old standard didn't have a chance or couldn't meet that those requirements can now meet that by a showing of what they plan to do and how it's going to impact the national interest. Now, I am going to turn our attention to one of the questions in the chat. On this one, let me pull it up for Jorge. Jorge, first of all, I would like to empathize and just say, I understand the difficulties you're going through. It sounds like you have a very, very difficult case. And I think this sort of case and fact pattern requires us to spend a little bit more time one-on-one with you. So feel free to reach out to us on WhatsApp. I'll put that in the chat and everything, so you can reach out to us, and Anai will go ahead and set an appointment up, and you'll be able to speak with us directly about your case, and we'll be able to address some of those unique issues in your situation. All right, Anai, take us to the next one. Or are we halfway? We're almost halfway through.
Yeah. So this one's for Lauren. I am a physician. How can I use the NIW to get a green card?
Yeah, so physicians are allowed to use the NIW to get a green card. So that's a really good thing as well. For the physicians, they must obtain a labor certification unless you are going to be working in some sort of area with a lot of need. So there are certain factors that you would need to think about: how many physicians are in the area. Is there a certified health shortage in the area? A lot of rural areas don't have enough doctors or physicians, so you would have to work in one of those areas for at least 5 years in order to be able to file the National Interest Waiver petition. But correct, you do not need, you may be able to file a National Interest Waiver without working in some sort of health shortage area for 5 years. If you can prove using the other national interest waiver standards that you're going to be, maybe you're doing some sort of research or medical technology. But in general, if you are working as a physician, just as a regular doctor, it would have to be in a health shortage area.
Thank you, Lauren. So we are halfway through our webinar. So here we like to do a fun question to get to know our attorneys and our staff. So Anthony, you have to decide one or the other. Do you choose steak or tofu, and why?
You're on mute, Anthony.
Thank you. Well, for me, it is going to be steak. I do prefer a filet mignon or a New York strip, medium well and prepared well. So, but I don't eat it a lot, even though I do love tofu in many dishes, especially a lot of Japanese style dishes, but steak would be preferred for me.
I'm also going to have to say steak. I'm not even that big of a steak fan, but I don't know who would choose tofu in this situation unless they are a vegetarian or a vegan. And I know Saki really wants to answer this question. So Saki. Oh, never mind. She's having an issue with audio. Saki, I'll answer for Saki. Saki likes mabo tofu. She gets it extremely spicy from a restaurant called Lao Sichuan here in Chicago. But I think she would probably choose steak with maybe exception mabo tofu. Ani?
So I would have to say steak. I've honestly never tried tofu, and the texture kind of freaks me out a little bit, so I probably would not try it. But definitely steak, and I like to top my steak with Tabasco and also shrimp. Let's go ahead and move on to the next question, and it's going to be for Lauren. What are some areas to prove exceptional ability in the sciences, arts, or business?
So for exceptional ability, what you would need to prove in general, we would like to show some sort of education degree in that field. We also highly recommend that you have at least 10 years of experience. We have to demonstrate that. So we can't just submit a resume saying that you have those 10 years. We would need letters from your previous employers on their letterhead signed by an official working at that company to prove that experience. Now, sometimes maybe from 10 years ago, the company is no longer in existence. It's been bought out. So there are ways that we can still prove your experience. However, in general, we do need those letters, as I discussed. If your field has some sort of license, for example, an engineer or physician, if you are, even if you're an attorney, there's certain types of licenses you need to practice your field. If a license is required, you would need to demonstrate that. Or if it's not mandatory, but you have it, that would be a really good thing to submit because it shows that you may be even better suited to have a job in your field, basically. Other factors are, do you have a high enough salary? If you are only making minimum wage, but you're saying that you're going to be this big shot in your field, USCIS is going to have some questions about that. Well, are you really going to be doing this type of work that you're saying you're going to be doing? Other type of work would be membership in a professional organization. For example, as an attorney, I'm a member of the bar. So something like that in your field. If you have any awards or some sort of recognition by others in your field, if you publish papers, if you spoke at some really big conference, really there's a lot of evidence that we can submit to show how you are practicing in whatever field you're practicing, and that you really are suited to further the field once you obtain the green card in the US. So those are just an example of some of them. We can work with you to make sure that the letters that you're showing are actually letters that we think USCIS will appreciate and really value as types of evidence. So definitely speak with an attorney and make sure that the evidence you're presenting, even if it's this type of evidence, is good caliber evidence to submit.
Thank you, Lauren. So Anthony, when should I file my NIW case? Do I have to be in the US?
Very great question. Thank you, Saki. So for the NIW, when should you file your case? A lot of this really depends on the strategy, and the strategy sessions we set up with our clients help us guide and figure out what is the best course of action. Now, obviously, if you're outside the US, you can file anytime right away. The sooner, the better. If you're in the United States, a lot may depend on the category, visa category you were already in the US. So it's what we'll do at our strategy session is figure out what is the best course of action. Another thing that impacts this decision is your own plans and schedules. Some people have businesses in their own countries. Some people are finishing up education, a degree. Others are trying to sell a home. So, or some others may be waiting for example, getting a bonus at the year end. So all of these factors will, call into question or kind of help us plan what is the best timing for the NIW. But simply put, with the NIW, generally speaking, you can file any time. The sooner, the better. Now, there's a lot of work to get this done. It's not like we can do this in a week or two. It may take, depending on how organized you are, or how much information you have, or how much information we need to get, can easily take anywhere from 4 to 8 weeks, sometimes even longer if we're building up that credibility, or for example, if we're waiting for 10 years of experience, or if we're waiting for a letter from an expert. It may take longer, but the point is to start. If you never start, you'll never get to that finish line. So the second part of this question is, do you have to be in the US? We sort of hinted at this earlier. No, you don't. Many people who are, well qualified are outside the United States, and they have their family, they have their business. You can continue to do that. So if you're in the Philippines or the UK or wherever you may be, you can stay in your home country, keep doing what you're doing, and we can get the process working. Now, once the I-140 is approved, then we'll start the immigrant visa process. We're not getting into details today, but you can still be in your country for that. Only once your immigrant visa is approved will you then need to start making plans to relocate permanently to the United States. So I hope that kind of clarifies that. If you guys have questions, please go ahead and put them in the comment sections about this or other immigration questions that you may have.
Thank you, Anthony. Another question for Lauren. How would I show substantial merit and national importance in my NIW case?
Yeah, so national importance is going to be a big one here. Similar to substantial merit. Basically, in layman's terms, we're trying to show that this is going to benefit the entire country. This isn't just a local issue that, people on your block have a problem with. This is going to be the entire country. So for example, let's say you are doing research on the opioid epidemic. Well, that is going to have national importance because people everywhere, it's in the news, are suffering from this. There's lawsuits against the manufacturers. So your research is really going to help further and benefit the US as a whole. Another example would be if you are doing something locally, but that local research or work that you're doing could be applied to the entire country. So, for example, whatever work you'd be doing here, let's say I'm in Chicago, and I am working in as a researcher, not in the opioid crisis, but on something with a more local level, local poverty. However, even though I'm focusing on Chicago, my research can be applied to the entire US. In that case, it would be really important to have an attorney to make that argument for you, right? So that's going to be USCIS's first question as well. What you're doing is only local to Chicago right now. So having an attorney to make that case that whatever specific tasks that you're doing can be applied to the rest of the country, and that you will apply them to the rest of the country once you obtain your green card.
Thank you, Lauren. Anthony, so how would I show that I am well positioned to advance my endeavor?
Thank you, Saki. So in this question, one of those fancy words that we use is endeavor. What does that really mean? It really means sort of your struggle, your undertaking, your goal, something that you plan on accomplishing. So how do you show that you're well positioned? There's many things that you can show or provide as evidence to do that. One is your education. Does your education prepare you to accomplish this goal? Me as a lawyer probably would not, my education background would not help a physicist, for example, or a scientist in their field that would impact the US. That would be a situation where you're not well positioned. In the Denisar case, which is a great example, feel free to look at more of the details of the facts. In that case, we had an aerospace engineer who was doing things at the national level for the US, teaching at a university and doing a lot of research. So his education, his or her education had, 2 masters and a PhD, well positioned that person for accomplishing their endeavor. Other things may be other accomplishments. For example, what have you done before? What are you doing now that will assist? Certain awards, things of that sort. Certain skill sets, licenses, and other things are certain things that will help or will position you to accomplish that. So just think of it as basically if you're going to save the world, you've got to show what skills you have in order to save the world and be able to, do that. What are your tools? So those are the things that's going to help you be well positioned for your endeavor. One of the things that's going to be beneficial in working with the attorney is we're going to review all those and make sure there's a connection or a nexus so that we're able to argue and explain that as we communicate on your behalf with the USCIS.
Thank you. Lauren, how would I show that on balance the waiver is beneficial to the US?
So in this case, we're talking about, yes, the waiver is whatever your work is doing. We've already shown that it is beneficial to the US. However, we also have to show that there is not going to be some negative impact to the US. So if you are doing some sort of research, again, in the opioid crisis, but this isn't true, but let's say there are a ton of people who are also doing the exact same research. Well, if you get the green card, then maybe that would impact another US worker who's also trying to get the same grants as you and is trying to further the research as well as you. So in that case, again, this is not reality, but if there were many opioid researchers and workers, they would say that, yes, your work is really beneficial, but on balance, this is going to harm US workers, so we're not going to approve this. So what in this case, we would like to show that there is no negative impact, right? So if there are not a lot of other people doing this type of specific research or work that you're doing, how would we show that? Are letters from really high up people in your field or government entities? Are you receiving grants? Are you able to show a benefit or show that there are not a lot of, maybe there's a lot of job openings, for example, in your field, to show that, hey, even if I get this job, we really need more and more people to do this. So kind of weighing that balance of, yes, my work is important, and also that we're not going to harm any U.S. Citizens or green card holders in the process.
Thank you, Lauren. So Anthony, this is all really exciting. And then my employer will not sponsor me for my green card. What are the next steps?
So, the next steps in this process is for you to reach out to an attorney to see if you actually, in fact, qualify or meet the standard that we're talking about. Now, just to refresh and go back and look at those standards, we're going to take a quick look at that. You know, is your endeavor, what you plan to do, have substantial merit and national importance to the U.S. That it's not your country, but the U.S. The next question we're going to be looking at and reviewing is, are you well positioned to advance that proposed endeavor? You know, do you have the education? Do you have the experience? Do you have the wherewithal in order to do that? Where are you going to do it? Do you have the facilities? Things of those sorts. And finally, we're going to evaluate that on balance, this is beneficial for the U.S. To waive the labor certification process. So the next steps is to reach out to us, let us know, you'll probably hear from us from the very beginning is, go ahead and send us your resume so that, we can take a deep dive into your experience and your education to see if you, in fact, really do meet this standard. Now, we don't want to waste your time or our time, so we're going to let you know up front whether, this is a strong case or whether it's not. But it's something worth looking into because you just don't need to have that employer cooperation, which sometimes can be challenging. So that's the next step. So one of the things, once you're on board and we solidify that you are a good qualified person, we'll get you on board, sign a retainer agreement, and then move into collecting information and all the documentation that we reviewed. We'll get expert opinions and testimonies. We'll document everything and then submit it to the USCIS. As you saw earlier, the processing times are quite lengthy. That's why you want to start earlier. This will not happen overnight. So start early. Don't wait. I mean, it's easily going to take at least a year or more for the USCIS to make that first decision. So get the process started, touch base with us. Now, remember, even if you don't qualify for the NIW, there may be other categories that you may fit in, and we're going to take a look at that too. So we're going to analyze all of that for you. Feel free to reach out to us. I think this is a great category for many people out there. So if you've ever, even if you don't know if you qualify, reach out to us.
We can't hear you.
Ani, do we have any other questions in the chat that we need to do?
Yes, from JJ. Sir, thank you. What is the age limit for J1 visa and H3 visa? I am 40 years old now. May I be eligible for J1 or H3 visa?
Yeah, I'll touch base on this, but basically, the J1 visa category has several subcategories. So it really depends under which of those subcategories you're applying to. Some have age restrictions, such as if you want to be care for children on au pair, I don't speak French, but that's one category that has an age limit, but many of them do not have age limits. So the nice thing about that is, there's a lot of freedom. However, there may be other requirements. So under the J1 category, if you just type in J1 sponsors, it'll take you to the travelstate.gov website. And the categories will be there. You can look at the requirements under each of those. Now, You do not need an attorney for the J1 visas. Therefore, you need to reach out to those sponsors and see what their requirements are. They'll have an application process, they'll list their requirements, and then you'll go through that process with the J1 sponsor. Under the H3, there is no age limitation. So being over 40 or 40 is fine. Now, again, you do have to meet certain requirements for the H3. One of those requirements are, you can't, if you've already have the training and experience, then there's no reason to come to the United States to be a trainee. However, we've worked with a lot of cases where people who are getting trained in a new field, such as doing sales and marketing in the United States in an American market as opposed to their home market, whether that's the Philippines or India, wherever you may be. So age limitations, you're good to go. Let's see, we went over age limits. Yeah, I think we're good on that question. Anna, go ahead. Anna, go ahead and wrap us up for today. Go ahead.
Thank you. So we wanted to inform you all that our next live January webinars will be on the 12th and 26th. On Wednesday, January 12th, 2022 at 11 a.m., we will have our Spanish webinar. In that webinar, we're going to go ahead and talk about how much money you will need to bring your family to the U.S. As we all know, it's not cheap and not free. On Wednesday, January 26th, we will have our next English webinar with our focus on the H-1B cap race. We will give you all the latest updates in our next webinar. Happy holidays to all of you guys. We hope you have an amazing holidays with your family and your loved ones. See you all in 2022.